Morning. Please be seated. As you know, you will each have 15 minutes, and the appellant may reserve up to 5 minutes for rebuttal. If you wish any rebuttal time, please let me know how much, and I will give you a hand signal when you are there, and hope that you will conclude and save the rest of your time. Thank you. You may begin.
Thank you, Your Honors. Counsel, may it please the court. This is a relatively simple case, and it was tried to the bench in a relatively simple manner. This is a case of 4 of 40, and factually speaking...
Did you wish to reserve?
Thank you, Judge. I wish to reserve the maximum amount of time.
5.
Thank you. 5 minutes. Thank you. This is a case of 4 of 40. My client, Mr. Vigilante, never disputed that he stole money from the victim in this case. And that issue was not under dispute. The dispute, singly tried, was what was the amount. As we know, that makes a significant difference. The threshold issue in this case for the state of Ohio was $7,500. In this case, the state of Ohio presented the victim who had trouble with her memory and could not identify who took the money, although she certainly suspected my client. The key witness was Sabrina Marshall. Sabrina Marshall was the bank manager at First American Bank. She indicated that on 4 occasions she could identify through use of photography that my client went to the ATM machine and withdrew funds. On the remaining 36, she testified in 2 different places, pages 63 and 67 of the transcript, that she could not identify anyone else who had taken the money. That was the key witness for the state. And we would indicate, as we did at trial, that there was not significant, sufficient evidence in this case to convict my client under the 36 transactions. The state of Ohio basically made an argument that if he did it 4 times, he must have done the other 36. And we respectfully asked this court to overturn the conviction, indicating that only on the 4 transactions did they present sufficient evidence of the case that should have proved beyond a reasonable doubt that he did it. There was also some indications from Sabrina Marshall that the victim could have done withdrawals on other ATMs. She could have done withdrawals at Walmart. As she purchased, she could have done additional cash withdrawals. There was also evidence presented by Sabrina Marshall that the victim could have made withdrawals by phone, and on at least 1 or 2 occasions did so. So there was, not only was there not evidence beyond a reasonable doubt, but there's also some other plausible explanations for some of the other funds to be withdrawn. So in this case, we would indicate that and ask you to overturn the conviction, saying there's not sufficient evidence. It's a simple matter.
Your client, I thought, reported to the police or sheriff's, I can't recall which, investigated, that he estimated his the amount of money that he stole to be around $9,000.
It's almost correct, yes. The police officer asked him many times how much money, and he said many times, I don't know. The police officer then said, well, please guess, and he said, if I had to guess, it would be, and then he came up with a number in that range, right? But that's a pure guess. He indicated multiple times it was a guess. He indicated from the beginning of the case in the police officer's testimony that he didn't keep track of any of the funds that were taken. He indicated he was surprised when the officer told him that this was the amount he thought. He also indicated he was surprised at the amount. But this is a case solely on that issue, and as to whether or not it's sufficient on the 440. We would indicate that the other 36 transactions, there's not sufficient proof. That clearly takes it under the $7,500 threshold, and my client should have been convicted of a lesser offense in this case. If there are no other questions, then I would rest, reserve the remainder of my time. Thank you.
Do you want to speak to the sentencing issue? I think you raised the sentencing issue.
Your Honor, we briefed the sentencing issue. However, my client, as I found out last week, is now released from prison, so it's not as much of an issue as we thought it would be. Thank you.
Good morning, Your Honors. May it please the Court, Counsel. My name is Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. As I understand it, Mr. Callow is essentially conceding the sentencing issue. In addition to his noting that the defendant was released, which under some recent Supreme Court authority, I understand for misdemeanors might make a difference, but for felonies might not render the entire issue moot. I would also note that setting aside the 2953-08G2, contrary to law, State versus Ballou, Lansinger, and O'Connor dissenting opinion about abuse of discretion no longer being the court's appropriate standard of review, even setting that aside and assuming for the sake of argument that it was abuse of discretion, I note for the court's consideration that there was a PSI ordered in this case. The appellant moved to supplement the record with that PSI. In August of last year, the court granted that motion, but it was never actually made part of the record on appeal. I've just checked with the clerk's office about 15 minutes prior to the day's argument. It was never made part of the court's of the record on appeal. And under April 10, it's the appellant's duty to ensure that that was made part of the record. So without that, you should presume validity and affirm the sentence. If there's no other issues with the sentencing portion, I'd move the court's attention to the manifest weight sufficiency argument. Excuse me. I guess for a moment, I want to focus the court's attention on a number of concessions that defense counsel has made both on brief and today. The argument is that he's conceded that Mr. Vigilante committed theft and that the victim was an elderly person as defined under law. So just starting there, we have the only issue remaining, the amount of the theft. And if the state proves, if the court finds sufficient evidence that the state proved at trial that the amount of the theft was in excess of $7,500, then that is a felony of the third degree, and the conviction must be affirmed.
What were the circumstances about this statement around $9,000? What are we going to see in the record?
Well, I think in the record you'll find that at transcript page 82, that the victim testified that when she confronted Mr. Vigilante, he admitted that he had stolen money from her. And
well, that's not the question. The question is the 90.
Sure.
Whatever.
Transcript page 105 is Deputy Keith Curtin's testimony about the circumstances of that. And at my recollection of the record, he says that, well, okay, you stole money from her. How much did you steal? And the defendant estimated that it was in excess of $9,000.
So without prompting us to an amount or anything?
No. He didn't say, well, was it?
He gratuitously picked that number.
I believe so.
So the transcript or the record will establish that.
I believe so, Your Honor. The other point that I would make for the court's consideration there is this is the defendant who has already admitted that he is the person who stole money from the victim's account by using the ATM in a manner that the victim and the bank manager testified about. So he's corroborating their testimony and admitting, yes, I did it, and I did it in that manner, and then goes on to make an estimate of I stole approximately $9,000, which turns out to be half of the actual amount the bank and victim identified as being fraudulently obtained. Of the 40 transactions, which the victim specifically testified she did not make, because she testified she never used her ATM card to make withdrawals from her savings account, which is where the $18,000 came out of. She testified she would make ATM withdrawals from her checking account. Absolutely.
And the record again will show that the savings account is the only account that was raided.
Correct. The victim testified at transcript page 86 that when she would pay taxes biannually, twice during the year, she would call the bank to transfer money from her savings account to the checking account and then write a check from her checking account to pay those fees, that she would only make withdrawals from her checking account using the ATM. Now, the other point that defense counsel has argued both on brief and at argument today is that the card was used to make point-of-sale transactions to withdraw money, and actually the bank manager specifically testified at pages 31 to 32 that the ATM card was not set up to make withdrawals from point-of-sales transactions from the savings account. It can only do so from the checking account. So the memory issues that the defendant claims, well, the way the defendant tries to make the memory issues on appeal is by saying she couldn't recall a mundane daily task that she had recently completed. What did you have for dinner last night? What did you do 2 weeks ago? I don't remember what I did 2 weeks ago, and I'm a 30-year-old man. I don't have any memory issues. Asking me to do the same thing under oath, on cross-examination, in a trial to the bench might be a little nerve-wracking, especially for an elderly woman.
How old was she at the time of trial, do you recall?
That escapes me, but she had no
Yeah, it's all relative.
Especially at my age, I'm just saying.
No comment. No. But clearly she was in excess of 65. She didn't have memory issues. She specifically identified ways that the defendant would trick her into thinking she had lost, and I'm putting those in air quotes, lost her ATM card, and then when she realized she didn't have it anymore, she would ask him, and he would find it, and by saying she dropped it in the garage or on her way into the house. No, as he later admitted, he was using the ATM card as he was forced to when they found 4 photos of him using the card without permission at an ATM. The photos of the ATM...
So again, excuse me, in the record, we won't find anything that he says that she gave him the ATM card and instructed him to do something for her that required his use of an ATM.
I mean, I don't believe that was the defense's trial.
Because he was doing many things for her.
Sure, right. But the victim specifically testified that she did not give him permission to use her ATM card. In fact, asking him, right, the ruse of saying that she had dropped it or she had lost it and he had found it would be unnecessary if she had given him the card with permission to use on her behalf to get money for her. That ruse would have been entirely unnecessary, but yet that's the one he went with when, he would steal her card without her knowledge. The 40 ATM transactions, 4 of which are actually on camera, the May 5th, June 1st, August 18th, and September 5th transactions, all of which involve either $500 or $300 withdrawals from the ATM out of the savings account. He admitted that he took the money. He confessed both to the victim and to the deputy. And so the only issue is the amount. And he said that it was in excess of $9,000. The total weight of the testimony, right, in a sufficiency challenge, it's sufficient if any witness testifies to this. But in a weight challenge, right, with competent, credible evidence, both the victim and the bank manager identified the total amount of the loss, approximately $18,000. And the victim specifically testified that he did not have permission to use her ATM card and she had not made those transactions. In fact, she testified and the bank manager confirmed that was inconsistent with her usual standard of practice. Up until May of 2013, she did not use the ATM card to make any withdrawals from her savings account. But then between the period of May of 2013 and September of 2013, when they figured out that money was missing, and they eventually confronted Mr. Vigilante about the missing funds, over 40 ATM withdrawals were made from the savings account, 4 of which they have photo evidence of him making. I think that there's sufficient evidence and there is competent, credible evidence upon which this court can find that the trial court did not err in convicting Mr. Vigilante.
Well, there was also, as I recall, the fact that these withdrawals were taking place, and then after Mr. Vigilante learned that there was an investigation, I guess he sat in on a meeting, that an investigation was taking place that the withdrawal stopped.
Correct.
So that was evidence that could be considered.
Right. The victim went to the bank in September of 2013 and talked with the bank manager and said, hey, I have money missing from my account. Mr. Vigilante was with the victim during that meeting and learned that she was now aware that there were missing funds from her account. Immediately after that meeting, there were no more ATM withdrawals from the savings account. The timing of that was, well, suffice to say, more than suspicious. But for all of those reasons, the trial court did not err in convicting Mr. Vigilante. His conviction is supported by sufficient evidence, and it is not against the manifest weight of the evidence. This is not the exceptional case where manifest miscarriage of justice occurred. For all those reasons, I would respectfully ask the court to affirm. Thank you.
Thank you. In rebuttal, I would just emphasize a couple things that need to be, I think, some attention needs brought up. The victim in this case wasn't being questioned about what she had for dinner, as indicated by the state of Ohio, or what happened to her yesterday. She was being asked specifically about transactions that she made. Her response was, I don't remember what I had for dinner. I don't remember what I did 2 weeks ago. That was her response. It wasn't a cross-examination. The cross-examination was asking her timely questions that were relevant, i.e. why the state of Ohio didn't object at trial to those questions. And she couldn't recall the relevant information in the case because the case had taken some time to go to trial because of her age and her ability to have a memory of those events. So she wasn't being asked about non-relevant things. She was being asked about, did you make these transactions? How did your card work? What did you make withdrawals from? Those are the things that she couldn't remember. So the victim in the case offers no evidence in support of the convictions. It specifically says that she couldn't identify who made these withdrawals. Also specifically, not in any ruse or any crazy way, directly, straightforward, asking the branch manager, can you identify who made those withdrawals? Speaking of the 36. And she, on 2 different occasions, straightforward says, only the 4. And the rest she can't. If you remember, in this case, this is a bench trial, the judge even took a break and specifically said to the bank manager and asked questions about, can you get the other photographs? Can you identify who did these things? And we took a break of trial, and she came back and she said, you know, it would take too much time and effort to do that. So we came to trial on a case very specifically on those 40 things. Now, you can have suspicions and you can suspect. And you can say, well, maybe it was him. And who else would it be? But that's not proof beyond a reasonable doubt. Proof beyond a reasonable doubt proved in the courtroom was that my client made 4 transactions. He was identified by the witnesses on 4 transactions. And the witness, the primary witness in the case, asked 2 different times, can you identify who made the other 36 transactions? And on both cases, she said, no, I cannot. That is straight, that is straightforward, and that's a defense to my client's conviction in this case. We ask that you overturn the case. Thank you.
Thank you. We'll take the case under advisement, send you a copy of the opinion when it's written, and of course you can always find it on the webpage. Thank you, and have a good day.